What's the law governing sharing private school tuition between parents for the children who attend private school? What are the standards that the court would look at in making that determination? Is there a way the children can attend the school anyways, even if the other parent doesn't want to pay for it? Those are some of the questions we're going to look at and others today. I'm Michael Miller. I'm a partner at Cole Miller PLLC. We're a family law firm located in Vienna, Virginia, serving primarily in the Northern Virginia area. I analyze challenges and find affordable solutions for families and their family law needs. So, as we've talked about in a couple previous videos, child support is based upon parents' incomes, cost of health insurance, cost of work-related daycare, and possibly the parenting time if each parent has more than 90 days. That determines the guideline amount. The guideline amount was presumed correct. However, the court can make written findings that the guideline amount is unjust or inappropriate and then deviate from the guideline amount. So that's kind of where the private school tuition is going to fall into place, is the court looks at whether the guideline amount would be unjust or inappropriate and then decide whether to include the cost of private school tuition and related fees and expenses as part of a child support order. And the case that is the dominant case that kind of lays out what this and that a lot of cases refer back to is Solomond, Solomond versus Ball, Ball. It can be found at 470 Southeast 2nd, 157, or at 22 Virginia Appeals 385. It's a May 1996 case. And basically kind of the history on this is interesting. The parties divorced back in 1988. Then in 1994, the mother had custody of the two boys, and enrolled them in one school and sought a deviation from the guideline amount. And after hearing, the court ordered that the father would pay 70% of all school-related costs, including but not limited to expenses, tuition, uniforms, books, transportation, supplies, registration, testing fees, and field trips, as such expenses and costs are due. So a couple problems coming up here. The court in its ruling also said that that it would reevaluate the circumstances because the boys potentially were going to end up in another school. And sure enough, that's what happened. As one of the boys got accepted, the other one got waitlisted. He was eventually admitted as well. And the thing they looked at here is that the children were moving from a public school where they had performed very well academically and moving over into this private school. So in the first go-round, the court went ahead, heard from the mother, and ordered the father to pay 70% of these expenses. And then it said that if the children succeeded in gaining entrance to another school whose tuition is higher, then that would constitute a sufficient change in circumstances to reevaluate the percentages. So, sure enough, as I said, the children got accepted to the second school with the higher tuition. Mother came back to modify, and the court went ahead and granted the modification and had the father share the cost. Now, the father did not appeal the first ruling of the court back in 1994, but he did appeal the second ruling of the court. And his a basis of appeal were two bases. One was he didn't like the $100 additional amount that was put towards him, and he also didn't like the amount of the tuition that he had to share. What he asked for was that everything be vacated. So we kind of have a procedural hurdle here to come up first, where the court looked at it pursuant to rules of Virginia Supreme Court, Rule 1:1. A trial court may modify or vacate a final order within 21 days after the order is entered, and no longer, because the order becomes final after 21 days. In this instance, the trial court was well beyond the 21 days, so it had no authority to vacate its order or to make any modifications to that 1994 order. So the Court of Appeals here said, therefore, we cannot disturb the trial court's finding that it was in the two boys' best interest to leave public school and go to private school. So that could not be undone. That had become, the status of the case. However, the Court of Appeals in the second go-round said we are not bound by the trial court's anticipatory language, that this kind of speculation that, well, in the event something happens in the future, we're going to consider that a change and so forth. The Court of Appeals didn't like that. They cited the Smith versus Smith case at 18 Virginia Appeals 427 that said implicit in the amount of child support in that statutory scheme is that educational expenses are included in the presumptive amount. So that's all been included in the presumptive amount. So the Court of Appeals in this, the second go-around here said that in determining whether or not a non-custodial parent should be required to pay support to provide for the children's private educational expenses, there's a two-pronged test or two conditions that have to be met. The first condition is there must be a demonstrated need for the child to go to that private school, and then the second prong of the test is the parent's ability to pay that. So some of the things the court looks at and the factors as to whether the child has a demonstrated need is you look at the availability and availability of satisfactory public schools. So in this instance, prior to going to the first public school, the boys were doing well academically in their public school. So in this particular case, that didn't exist. However, the father didn't appeal in time, so not really a player in this second case here. But for other cases, and if you were to bring this up, that's one thing the court has to look at is, do the public schools meet the children's needs? Also, we look at the children's attendance at private schools prior to any separation or divorce. So again, if the children, there's several of them, they all have a history of going to a private school, that would be favored to continue post-divorce. Also, we look at any of the child's special or emotional physical needs, religious training provided by the school, and then we also look at the family tradition. If the grandparents went to a particular private school and the parents went to a particular private school, it would make sense that the children do as well. So that's the two things the court looks at is the needs of the child, and then the second thing is the ability of the parents to pay. And this is where the opinion kind of doesn't provide as solid footing as we would otherwise hope. It says here that the trial court's only stated reason for increasing the amount of the father's child support was that it would be in the children's best interest to be able to take advantage of the opportunities. The court made no written findings of fact as required by Virginia Code 20-108.1 that justify deviation from the guidelines. So that's kind of where this case, and there's several other ones that came up in the few years following this, is not so much a flat-out ruling on it as it is the court saying from the record that was presented, we do not find that the judge made the necessary written findings that the guideline amount was unjust or inappropriate. So although the mother attended this second private school and testified that it would be her preferred institution, the record before the Court of Appeals does not demonstrate a need of either child that was not being adequately met by their first private school. Also here, the trial court set the father's support obligation as a percentage of the children's educational needs. That's a problem. It has to be a particular, specific dollar amount, not just a percentage of expenses as occurred or anything like that. So what happens here where the record is insufficient, and we see here in the last line of the opinion is that the ruling of the trial court in the second hearing was affirmed in part, and that when the trial court denied review of the order that was final, that part was affirmed, and some other parts it was reversed in part from the determination of the percentage, as well as not having the sufficient findings of fact to deviate from the guideline amount. And then what happens here is the case gets remanded. So the Court of Appeals has looked at the record, identified the deficiencies of the record, and explained what the applicable law would be. And now the case gets remanded back down to the trial court. And that's frequently what we see in these cases is it doesn't come back up on appeal for a second or third time. It goes back. The judge should then have further hearing to follow out the instructions laid out in the opinion. And then oftentimes, in this instance, if it went back and the judge said, well, I'm supposed to make specific findings that the amount of support is unjust or inappropriate, I don't find that to be the case, so therefore no obligation to share tuition. The mother may leave it at that. Likewise, the court may come back and say, okay, fine, if you want those specific findings, and go through and make all the detailed findings necessary to support the outcome. And the father may say, okay, well, you got me. That should meet the statutory requirements, therefore I'm not going to appeal that. It could also be they just run out of resources to keep doing the appeal and decide they'd rather spend the money on their children's welfare rather than spending the money on their attorney's welfare. So a couple things here, but that's usually the touch points that you want to look at is if parents are talking about changing the guideline amount of support to include tuition is the welfare of the child and the parent's ability to pay that.